live na.
Good evening, everyone. Welcome again to another live streaming of Basic Transfer Pricing. Good evening, everyone. Welcome again to another live streaming of Basic Transfer Pricing. Our topic tonight is about licensing of intangibles and payment of royalties. And we will discuss also the case of Japan versus Uyemura and Company Limited. So today is May 26, 2021. And I would like to say thank you po sa ating mga subscribers. And then, shout out, Hari.
Wala akong shoutout naman, pero may viewers po na 6 viewers.
Okay. So, our topic is about licensing of intangibles and the payment of royalties. What is this payment of royalties? The payment of royalties is the price agreed upon by the parties who is the owner of the intangibles and also the other party who wanted to use the intangibles. No? Kaya there is what we call as licensing of intangibles. And the consideration or remuneration for that licensing is what we call as royalties. So just like in this case of Uyemura and Company Limited, this is all about the licensing of the intangibles owned by a Japanese company, Uyemura, and it was reassessed by the Japanese tax authority. So we will discuss this case tonight, and the essence or the topics is about the licensing of intangibles. Okay. So this is a case filed in the Tokyo District Court. Case number 267-141, order number 13090. Tax litigation materials number 267-141, order number 13090, at the Tokyo District Court case. Okay. This is a request for cancellation of correction of corporate tax. National Party, National Government, Director General of Higashi Tax Office. Parang district office, Higashi siya ng BIR nila doon or the National Tax Agency. Dismissed an appeal on November 24, 2009. Tagal na palang kaso to, Hari.
2017
yung
sa taas mo na.
November sa taas ito November 2017, Okay. Sige. Kasi yung case 2009 pa. Kasi appeal na to, Okay. Sige. The plaintiff's claim are dismissed in their entirety, The plaintiff shall bear the cost of the suit. Sino yung plaintiff dito? Kasi ang title dito is Japan versus Uyemura and Company Limited, Okay. So what happened in this case? Sino yung nanalo dito at saka sino yung natalo? Kasi yung talo, sa kanya naka-charge yung cost. Okay. Sige. Let's start. As I told you, gusto ko sa case, yung long case. Kasi nadidiscuss yung mga deliberations, yung mga argument and counter-arguments ng parties, Yung in short, gusto ko yung naglalabanan, hindi yung sasabihin na lang kaagad yung resulta, So the the purpose of the claim, and the facts of the case, no, uh, the director of the East Tax Office, ito yung pinaka-BIR po ng Japan, National Tax Agency, no, issued a correction of corporation tax for the fiscal year from April 1, 1999 to March 31, 2000. Actually, this is just one case, pero ang daming cases nito, no? Isang case pa lang to, yung 1999 to March 31, 2000, fiscal year ending March 31, 2000, no? To the plaintiff on March 30, 2006. The case of fiscal year April 1, 1999 to March 31, 2000, fiscal year ended March 31, 2000, and fiscal year ended March 31, 2000, reassessment. Ibig sabihin ni-reassess na, no? Was made on March 30, 2006. No? Referred to as the correction for the fiscal year ended December 31, 2001. Okay. So after the partial reversal by the decision of the Director of the National Tax Tribunal, dated November 8, 2012, the portion of income exceeding 541,074,943 yen and tax amount payable exceeding 434,454,200 yen and the portion of additional tax on underreporting. Underreporting, under declaration. No? Kasi hapon ito iba yung mga terms nila. The amount of income 1,510,074,943 yen. The tax amount exceeding 434,445,200 yen and the additional tax for underreporting after partial revocation of the decision of the Director of the National Tax Tribunal dated November 8, 2012 are revoked. No? Revoked. Ibig sabihin, wala na. Number 2, the reassessment of corporate income tax for the fiscal year from April 2000 to March 31, 2001. So ito yung fiscal year ended March 31, 2001, made by the Director of the East Tax Office to the plaintiff on March 30, 2006. So noong 2006, sabay-sabay silang nag-assess, no? Kasama na dito yung fiscal year ending 2000, March 2000, March 2001, merong March 2002, merong March 2003, March 2004, no? So magkakasama sila na ni-reassess. Okay. So yung April 1 to March 31, 2002 naman, the Director of the East Tax Office made to the plaintiff on March 30, 2006 is reversed, no? So this was not the case for the fiscal year 2001 to 2002, no? Correction for the fiscal year ended March 31, 2002 for the fiscal year ended March 31, 2002. Okay. Ni-revoke, no? Yung 2003 naman, revised disposition, ni-revise. Yung 2004 naman, part of the disposition exceeds 162,000 yen in the amount of additional tax shall be revoked. So, hindi lahat ni-revoke, no? Okay. So, with respect to the complaint for the purpose of the claim, the East Tax Office made a correction to the plaintiff for the fiscal year March 31, 2003. However, the reduction of correction dated January 28, 2010 and the partial reversal by the decision of the Director of the National Tax Tribunal dated November 8, 2012, the amount of income was 1,423,988,814 yen. The amount of tax payable did not exceed 242 million. The amount of tax underreported was determined to be imposed. No? So may underreporting of income. The amount of tax underreported was 1,624,000 yen. However, after the partial revocation by the decision of the Director General of the National Tax Tribunal, dated January 28, 2010 and November 2012, we reject the request for the revocation of the part of the disposition on the imposition of additional tax on underreported income not exceeding 238,000 yen. No? Okay. So, outline of the case. Ano nangyari dito sa case na to? No? Director General of the Ace Tax Office has requested the plaintiff. Sino yung plaintiff dito? Si Uyemura. No? Engage in the business of manufacturing. So, siya yung nagmamanufacture, nagbebenta ng plating chemicals. Ano tong plating chemicals? Ito yung parang binabalot niya kung ano man yung mga parts, no? Binabalot niya ng chemicals, plate, no? To rescind the grant of a license for the use of intangible assets. Ito yung involved dito, yung intangible assets niya na ginagamit niya na know-how sa kanyang manufacturing ng mga plating materials, chemicals. Yan yung nilicense niya sa ibang company. No? At ang sabi po ng National Tax Agency, yung bayad na charges niya for the payment of the royalty dun sa license niya, the use of the intangibles is not arm's length. No? So, ibig sabihin na is not arm's length, hindi sapat yung consideration nila doon sa pagbabayad. Why? Kasi if you try to look at some transfer pricing cases, they are related parties. No? Kaya it doesn't matter to them, tama ba o hindi tama yung kanilang mga charges, doesn't matter to them. No? Kasi sila-sila pa lang din. They are group. So with respect to the transaction of licensing of intangible assets such as technology and know-how relating to the manufacture and sale of plating chemicals and the provision of services between the plaintiff and a foreign affiliated person as provided for in Article 66-4(1) of the Act on Special Measures Concerning Taxation as amended by Cabinet Order Number 105 of 2004. If the amount of the consideration paid by the plaintiff to the foreign affiliated person was less than the arm's length price. So, kulang yung binayad niya sa foreign person. Calculated by a method equivalent to the residual profit split method. As we go along in this case, makikita po ninyo that the Japanese are very particular of the transfer pricing method. No? So, anong ginagamit nila dito? Residual profit split. Mahirap po gamitin ang profit split method because pagka ang ginamit mo, profit split method, wala pong comparables yan. Why walang comparables? Because of lack of independent parties where you can compare or benchmark the transactions. So, ang nangyayari pagka profit split method ang ginamit mo, ang ibig sabihin lang the activities of the taxpayer or the business is highly integrated. So that is one of the justification that you can use the profit split method, or each of the participants in the transactions are contributing intangibles. No? So yun po yung titingnan natin yung bagong guidelines on the profit split ng OECD. No? So each of the participants to the transaction should have contributed an intangible. No? So, kaya po pwede sila na profit split. Okay. So, ang contention dito is that the remuneration or the payment is not arm's length, no? The arm's length price method. Provided for in Article 39-12, Paragraph 8 of the Act on Special Measures Concerning Taxation. Itong special measures concerning taxation, ito yung kanilang transfer pricing law, no? As amended by Cabinet Order number 105 of 2004, the plaintiff shall be entitled to receive the arm's length. Kasi yun naman yung aim natin talaga, no? That we have to apply the arm's length price. The arm's length price. As a result, the plaintiff filed the reassessment and the determination of imposition of corporate tax for the fiscal year ended March 31, 2000 through March 31, 2004. So, 2000, 2001, 2002, 2003, 2004. So, 5 years po yung involved dito. No? The reassessment, ito yung reassess sa si Uyemura. In this case, the plaintiff seeks the revocation of the portion of each of these reassessments. So, nag-protest po yung Uyemura. No? Revoke niya yung mga reassessment. So, after the partial revocation of the reassessment of corporate income tax, the reassessment of additional tax on underreporting and the decision by the Director of the National Tax Tribunal that exceeds the declared amount on the ground that it is inappropriate to adopt a method equivalent to the residual profit division method as the method for calculating the arm's length price of the above-mentioned transactions, and that there are errors in the calculation process. Mahirap po gamitin ang profit split method kasi una-una you have to determine what are the profit that you're going to split. This case is a request for the revocation of the part of the disposition that exceeds the declared amount. So pinapa-revoke ng Uyemura yung reassessment sa kanya. Okay. So ito naman yung mga related laws, no? Provision of relevant laws and regulations. The provisions of the relevant laws and regulations are set out in Appendix 1. The abbreviation set out in this appendix shall also be used hereinafter. So assume facts that are not in dispute between the parties that are admitted by the evidence presented. Ito na yung maganda kasi pagka may sinabi ka na assume fact, it is accepted by both parties. So there's no point for dispute. No? Kasi accepted na nila yung assumptions na yan. Parties. The plaintiff established. Sino yung plaintiff dito? Yung corporation, no? Si Uyemura. So the plaintiff established in 1933 is a domestic corporation engaged in the manufacture and sale of plating chemicals. No? Ano ba yung plating? Parang yung sa gold plate, di ba? Yung chemical siya, halimbawa may mga jewelries ka. Parang liquid yung gold na yan, yung gold plate. Idaan mo siya para balutin mo yung jewelries mo para magmukha siyang gold, no? So, ang sa kanila is plating chemical. So, whatever yung piniplate nila, na tatakpan siya, na babalot siya ng chemicals, no? And surface treatment machinery, no? So, yung mga surface treatment ng mga machinery. So, very important yan sa maintenance ng machine, no? And the purchase and sale of industrial chemicals and non-ferrous metals. Siyempre, yan na yung line of business nila, no? So, nag-plating sila ng chemicals, and then meron silang surface treatment ng machinery, and of course, yung kanilang raw materials na ginagamit, kasama na rin yung sa binibenta nila, which are the industrial chemicals and non-ferrous metals, no? So, B Limited, hereinafter referred to as B Company, kasi marami po silang company na involved dito, no? Yung mga subsidiaries ng Uyemura, situated in different countries just like Shenzhen, no? Yung economic zone ng China, napaka-advanced ng Shenzhen ngayon. Meron siyang branch doon, no? Sa Shenzhen. Meron din sa Thailand, meron sa Malaysia. Okay. B Limited, hereinafter referred to as B Company, hereinafter referred to as B, has its head office in Taiwan. No? So, meron din sa Taiwan. And is engaged in the business of manufacturing and selling plating chemicals and purchasing and selling surface treatment machinery. In each of the fiscal years in question, the plaintiff held more than 50% of the total number of issued shares. The ratio was 76% the fiscal year ended March 2000. If you try to look at dito sa facts of the case na to, bakit niya nila binibigay yung shareholding ng company, ng B company? In order to establish control o kaya relationship, di ba? So if you are the owner of 76% ng isang company, you are already the majority stockholders. Kontrolado mo na yung company. No? 76.11% in the fiscal year ended March 2000. No? So CB company has control over the involved na company po dito. No? And 87.78% the fiscal year ended March 2002 through March 2004. Hereinafter referred to as the C Company is a foreign corporation which holds 76.11% of the shares of the company for the fiscal year ended March 31, 2002 and 87.78% for the fiscal years ended March 31, 2002 and March 31, 2004. Kaya ang galing ng pagka-present dito kasi una pa lang, pinipresent na talaga nila, pinapakita na talaga nila that there is really an element of control between the group. No? Sa ibang case, makikita naman natin, kagaya yung diniscuss natin na huling case, wala silang ginawa. Pagdating na sa Supreme Court, dinesisyonan lang nila yung isang term, no? So, ganun kasimple, mag-decide ng case. Why? Kasi pag na-establish mo na one party is significantly influenced by another party, then tapos na yung usapan. Kasi ang ibig sabihin lang, there is an element of control. And when there is an element of control, the other party is forced to accept the transaction, no? Which is detrimental to it because inimpose lang sa kanya ng kanyang parent company. No? So, in this case, C, hereinafter referred to as Company C, is a foreign corporation which has its head office in Malaysia. No? Saan ba ang economic zone ng Malaysia? Nasa Selangor, no? Nandun yung industrial area nila, no? Sa Selangor, Malaysia. Although malapit lang din siya sa Kuala Lumpur, no? Has its head office in Malaysia, is engaged in the business of manufacturing and selling plating chemicals, is a foreign corporation in which the plaintiff owns 100%. Oh. Ang ownership naman ni Uyemura kay Malaysia is 100%. No? So pag 100%, wala na. Talagang dependent na lang siya sa head office. 100% of the total number of issued shares in each of the business shares in question and is a foreign related party of the plaintiff. No? Related party talaga niya, 100% owned pa. No? Okay. Next, D, another company to. Hereinafter referred to as Company D. Bakit inisa-isa yung mga companies dito? Kasi sila itong binigyan ni Uyemura ng license to use the intangibles. At ang sabi ng Japan Tax Agency, hindi arm's length yung price na pinapabayan mo sa licensing mo ng intangibles. Kaya pinapare-assess, no? Pinapare-assess ng Japan. So si D, hereinafter referred to as the Company D, is a foreign company which has its head office in the Republic of Singapore. So si D naman, nasa Singapore. Hereinafter referred to as Singapore. D, referred to as Company D, has its head office in the Republic of Singapore, is engaged in the business of purchasing and selling, plating chemicals and surface treatment machinery, is a foreign corporation in which isa lang sila ng business, no? Isa lang naman sila ng may-ari. In which plaintiff own 100%. So, si Malaysia kanina, 100% own niya. Si Singapore, ganun din, 100% own. No? Of the total number of issued shares in each of the business shares in question and is a foreign affiliated person of the plaintiff. No? So, sino yung mga foreign affiliated person niya? Yung mga wholly owned subsidiaries niya. No, sa Singapore, sa Malaysia, sa Taiwan. Contracts between the plaintiff and Company B. No, si Company B. The plaintiff and Company B entered into a know-how license agreement dated June 1, 1997, referred to as the former B agreement. Thereafter referred to as the old B agreement. The plaintiff grants Company B a non-exclusive right. Pagka makita na po natin sa description, non-exclusive right, no? Especially in the licensing ng intangible. And the licensing grants a certain party a non-exclusive right. Ano ibig sabihin ng non-exclusive right? Pagka non-exclusive right, mas mura siya kaysa doon sa exclusive right. Kasi pag non-exclusive, ibig sabihin, the owner of the intangible can still license or allow other parties to use that same intangibles. Kaya nga, ang tawag sa kanya is non-exclusive. No? Pagka ganyan ang consideration, dapat mas mura siya. No? Pero kung exclusive yan, then that is very expensive. No? So, grants Company B a non-exclusive right to use the technical information related to the products. The plaintiff experience, knowledge, technical data, business secrets, ang dami intangibles niyan. Manufacturing methods and other information related to manufacturing, sales, and commercial inventions and improvements to manufacture, distribute, and sell the products in Taiwan. And to disclose the manufacturing methods and other know-how related to the products. Company B shall provide services to the plaintiff in the form of technical training for Company B's employees at the plaintiff's factory and technical support for the plaintiff by sending the plaintiff's chemical experts to Company B. No? So, ganun sila ang Japano, ganun ka, they are very particular of training. No? Talagang kahit na simple lang yung task mo, pag first time ka pa, hindi ka pwedeng diretso na uupo sa trabaho mo na hindi ka muna nakatrain, no? Kasi parang sa kanila there's a lot of wasted time and wasted resources pagka ang isang tao hindi marunong at pinahawak mo na lang kaagad ng trabaho, no? So training is crucial. So thereafter, the plaintiff and Company B entered into a new agreement by means of a technical cooperations and license agreement. So sino to? Si Company B at saka yung ating taxpayer, siya yung plaintiff, si Uyemura, no? So nag-enter na sila into a technical cooperation and license agreement dated April 1, 2001, hereinafter referred to as the New B Agreement. So in the new agreement, the plaintiff granted Company B an exclusive license to manufacture, sell, and use the products listed in the Company B and new agreement columns of the product list in Taiwan. So using the license patents, if you recall, yung list na mga customers, they are also considered as intangibles. So the product list in Taiwan using the license patents and technical information, all information and knowledge used by the plaintiff in connection with the manufacture and use of the products, granting the plaintiff an exclusive license to manufacture, sell, and use the products in Taiwan using the license patents and technical information, all information and knowledge used by the plaintiff in connection with the manufacture and use of the products, and providing the plaintiff with services consisting of accepting trainees from Company B to the plaintiff factory for technical training and sending the plaintiff engineers to Company B's factory. So for technical guidance, Company B paying the plaintiff a royalty of Company based to the plaintiff a royalty of, hindi nila sinasabi kung anong rate na royalty, no? Percentage lang, of the net sales price of the product sold by Company B under the contract, and the term of the contract is 5 years, no? So 5 years po yung term ng contract. The plaintiff and Company B entered into a transaction for the licensing of intangible assets, such as manufacturing know-how, relating to plating chemicals, and the provision of services based on the agreement in each of the above agreements. So hereafter referred to as the B license transaction. However, the products subjects to the B license transactions are not necessarily limited to those specified in the above mentioned agreement, but include the products that were actually the subject of the transactions and licensing of intangible assets such as manufacturing know-how and provision of services between the two companies, and the same applies to the C license transactions, E license transactions, and F license transactions described below. The same shall apply to the C license transaction. So ito na yung mga licensing transactions nila. Marami, because if you try to remember, yung from Uyemura, ang dami niyang companies na halos lahat ng companies niya, na subsidiaries niya, binigyan niya ng license agreement to use the intangibles na ginagamit niya sa manufacturing. Okay. Contract between the plaintiff and company C. So, contract between the plaintiff and company C, the plaintiff and company C entered into a know-how license agreement, dated December 1, 2000, referred to as the old C agreement. Kanina si B, di ba? May old B agreement. Ngayon si old C agreement naman. So C agreement, the plaintiff and company C entered into an agreement dated December 1, 2000, whereby the plaintiff agreed that company C would provide the plaintiff with know-how, technical information, and data useful for manufacturing the products consisting of chemical composition, manufacturing procedures. So ito talaga yung business ni Uyemura, no? Raw material specifications, product quality control procedures, and equipment specification. To be disclosed by the plaintiff for the products listed in the company C and former C agreement columns of the product list, and other technical information disclosed by the claimant, granting the claimant an exclusive license. Ito exclusive, kanina non-exclusive non-exclusive license yung kanina. Dito naman, exclusive license. So wala nang iba, siya lang mag-isa yung binigyan. Exclusive license to manufacture, use, and sell the products in Malaysia. No? Sa Malaysia naman to. And providing the claimant with services consisting of receiving employees of company C to the claimant's factory for technical training and sending the claimant technical experts to company C for technical guidance. No? Talagang very massive sila talaga at saka talagang nagtitrain sila. No? So the plaintiff and company C concluded a new agreement by means of a know-how license agreement. So si C, gumawa sila ng agreement, no? Yung know-how license agreement, dated January 7, 2003. Okay. So the new agreement contained the following provisions. Ito pagka kasi tumingin tayo ng kontrata, and then along that contract, sa loob ng kontrata na yan, nakapaloob dyan yung mga iba't ibang provisions, no? So tingnan natin kung yung mga provisions na yan are arm's length, no? Okay, so ito yung provisions. Number 1, the same terms as in above except that the product in question were those listed in the company C and new agreement columns of the product list. Company C would pay to the plaintiff a royalty of blank percent of the net sales of the product sold by company C during the term of the agreement, and the company C would pay to the plaintiff a royalty of blank percent of the net sales of the product sold by company C during the contract period, and that the contract period would be from the 1st of the same month to the 31st of December 2007. Okay, so yun po yung agreement nila. Excuse me. Doon sa licensing nila ng intangibles. So the plaintiff and company C conducted transactions for the licensing of intangible assets, such as manufacturing know-how related to plating chemicals and the provisions of services based on the agreement in accordance with the above-mentioned agreement. So the foreign-related transaction, the C license transaction, The product of plating chemical manufactured by Company C using the intangible assets such as manufacturing know-how, licensed under the C license transactions, referred to as C license product. No? So pagka ang na mga products that has been manufactured because of the agreement, no? Na nagkaroon sila ng license agreement. Anong tawag nila? C license product, no? So license product na yun kasi ang ginamit mo, know-how ng parent company na binayaran din naman nila na royalty, no? So together with B licensed products, so may C licensed products na siya, may B licensed products. Balikan na lang natin, ano ba ang issue dito? Ano ba yung hinahanap dito ng tax agency ng Japan, National Tax Agency? Ang hinahanap niya dito yung arm's length remuneration of the or the royalties as payment for the use of the intangibles. No? So anong issue talaga dito? The licensing of the intangibles and the payment of royalty. So pinagamit mo na yung intangibles mo, tama ba yung bayad doon? No? So yun yung inassess uli sila ng tax authority. No? Okay. All of the products manufactured by Company C using intangible assets such as manufacturing know-how, hereinafter referred to as the C licensed products and together with the B licensed products, no? So, take note, meron ditong tinatawag na C licensed products, merong B licensed products, merong D licensed products, no? So, ito na yung mga products na manufactured out of the intangibles na ni-license ni Uyemura. And then sold by Company D to non-related parties, no? Referred to as the C transactions, including the foreign related transactions between the plaintiff and the Company C. No? Contract between the plaintiff and Company E, no? So andyan naman si E. Sino naman to si E? No? Between plaintiff and E, hereinafter referred to as the E license transactions. No, ano naman yung license niya dito? Ganun pa rin. Manufacturing know-how related to plating chemicals, provision of services based on the agreements. Si E naman to. No? Saan naman si E? Si E has its head office in the Republic of Korea. No? So, Korea naman si E. No? Referred to as Korea and is not a foreign related party of the plaintiff. The plaintiff and Company A has its head office in the Republic of Korea and which is not a foreign related party of the plaintiff entered into the know-how license agreement. No? Okay. All information, data, or documents concerning the know-how and other technologies used for the manufacture and assembly of the contracted products granting the plaintiff a non-exclusive license. Si Korea, non-exclusive license. Yung kanina, si B, exclusive license siya, no? Si D, no? Exclusive license siya. Dito, non-exclusive license. To manufacture and sell the contracted products in Korea, accepting trainees from Company A to the plaintiff factory for technical training. Talaga ang Japan, mahilig talaga sila mag-offer ng mga training, no? Sa Japan, pinapapunta doon yung mga employees para makapag-aral, no? Kasi kaya nga alam ko because I was also a recipient of the JICA grant, no, ng scholarship sa Japan. So for technical training and sending the plaintiff's engineers to Company A's factory for technical guidance. O dinadala nila yan sa factory nila and then tinitrain. So, Company A provides the plaintiff with a royalty payment percentage ng sales. No? Contracted products manufactured by Company A. Okay. A portion of the contracted products is exempt from the obligation to pay royalties. The contract term is 5 years. So, ganun yung kanilang agreement. The plaintiff and Company A entered into a new agreement by means of a know-how license agreement dated December 1, 2002 referred to as the New E Agreement. The new agreement provides that the plaintiff shall provide Company E with know-how, technical information, and technical data useful for the manufacture of the contracted products, and other technical information. Okay. So, Company A shall provide plaintiff with the contracted products manufactured and sold by Company A during the term of the contract as royalties. No? So, Company A pays the plaintiff. Si Company A, binabayaran niya si Uyemura ng royalties. No? Pero, in this case, hindi nila sinasabi. No? Okay. So, contracts between the plaintiff and F. Iba naman to, no? So, nasa F na tayo. Mag-umpisa tayo dun sa B kanina. Sino naman to si B? Si B has its head office in the Kingdom of Thailand, no? So, si E sa Korea, si F naman sa Thailand, no? Hindi raw siya foreign-related party because may head office siya sa Kingdom of Thailand. Okay. So they entered into an agreement by means of know-how license agreement dated May 1, 1999. No? So the F agreements, the plaintiff provided Company F with know-how. Sino yung magpo-provide? Si Uyemura, no? Know-how, technical information, and data useful for manufacturing the products consisting of the chemical composition, manufacturing procedures, raw material specifications, product quality, control procedures, and equipment specifications. So lahat ng dapat malaman ni F, pinoprovide ni Uyemura, no? So, provided Company F with technical information with respect to the products listed in the Company F column. So, yung product developed by company, by Uyemura, may product know-how, product knowledge si Company F. No? F shall provide the plaintiff with the following services. F shall provide the plaintiff with an exclusive license to manufacture, use, and sell the said products in Thailand, and shall provide the plaintiff with technical training by accepting F employees to the plaintiff factory, and shall provide the plaintiff technical experts with technical guidance by sending them to F's factory. So, Company F shall pay to the plaintiff in addition to the royalty of yen, a royalty of the net cost of production of the products manufactured by Company F during the contract period, and that the contract period shall be 5 years. No, so ganyan. Alam nyo, ang Japan mahilig sa 5. No? Kung ang Chinese mahilig sa 6, di ba? 6-6 sila. 6-6 yan. Pagka gumawa yan sila ng product, set of 6 yan. Ang Japan naman, set of 5. No? Kaya yung mga set nila ng mga baso, set nila ng mga pinggan, 5 yan. No? Kaya dito, ano nang ginawa nila dito? 5 years yung kontrata. Actually, meron akong ginagawang transfer pricing dyan. Hari, yung katatapos lang ngayon, that is also a Japanese company. Pangalawa na yan sa series ng, ilan ba nagawa natin na transfer pricing study na mata ko. 13, no? So, pang 13 yan. Pero nauna pa siya natapos dun sa iba kasi yung iba, mga kulang-kulang yung requirements. No? So, mahilig sa 5, no? Yung kanilang mga contracts, yung mga terms, 5 years, no? So, in this case, makita nyo, ganun din. Mahilig sila sa 5, no? Kasi maswerte daw ang 5, no? Anyway, ako, yung birthday ko is 5 November 5. Kaya mahilig na lang talaga ako sa 5 kasi pinaninindigan ko na yan kasi birthday ko no? So, background of the corrective action. So, yung kanina, those are the backgrounds ng mga kontrata na entered into between Uyemura and its subsidiaries or its related parties. Ito naman yung corrective action. Ano itong corrective action? Ito yung assessment, ito yung mga findings, or ito yung mga adjustment ng tax authority finding what are their transactions, no? So, with respect to the corporate income tax for each of the fiscal years in question, the plaintiff submitted to the director of the Higashi Tax Office, parang district office sa atin, no? A tax return or regional office, no, sa atin. Kasi ang sabi niya dito is director, no? Director of the Higashi Tax Office. With the details set forth in the final return column or appendices on the data set forth therein, and the director of the Higashi Tax Office issued a correction for the corporate income tax for the fiscal year ended March 31, 2000 on May 30, 2001. No? So, binigyan sila ng assessment. Assessment sa atin yan, pero sa kanila ang tawag nila correction. No? So, reducing the amount of income and the amount of tax to be paid as set forth in the correction for reduction column of Appendix 1. Anong ginawa ng tax authority? Binawasan nila yung income, no? And sinabject po sa tax. So, reducing the amount of income and the amount of tax to be paid as set forth in the correction. So, binawasan nila yung income and binawasan din yung tax to be paid, no? Yan yung ginawa nila sa correction for reduction. So, in addition, the plaintiff submitted to the director of the East Tax Office on June 2, 2003 an amended tax return. Inamend yung binago, inadjust yung tax return. For the corporation tax for the fiscal year ended March 2001 and 2002, with the details stated in the amended tax return columns of appended table 1, 2, and 3, the plaintiff submitted the amended returns to the Chief of the East Tax Office on June 26, 2003, and the Chief of the East Tax Office issued a decision on the imposition of additional tax on underreporting. No? So, ang ginawa ng Uyemura, kinurek niya, nag-adjust niya doon sa income niya. Ang ginawa naman ng tax authority, dinagdagan. No? So, yung taxpayer binawasan, yung tax authority dinagdagan. No? Parang nangyayari din sa atin pag nag-renew ka ng business permit mo, yung sales, ang taxpayer, hindi lahat i-declare, binababa yung sales. Pagdating naman sa City Hall, hindi sinusunod nung nagko-compute. Anong ginagawa? Dinadagdagan naman. So, in both parties have different goal or objective, no? Ang isa binabawasan, ang isa dinadagdagan. No? So, paano sila magkasundo? The East Tax Office issued a decision on the imposition of additional tax. So, may nag-decide naman yung tax office na mag-impose siya na additional tax. No? Or underreporting as described in the decision, as against doon naman sa ginawa ng tax ni Uyemura na nag-amend siya ng tax returns, tapos binawasan niya ang income, binawasan niya yung tax. No? So, on March 5, 2004, the plaintiff filed a tax return with the director of the East Tax Office for the corporation tax for the year ended March 31, 2003. So, in addition, the plaintiff submitted an amended tax return for the year ended March 31, 2003 to the director of the East Tax Office on March 5, 2004 as described in the amended tax return column of Appendix 1-4. So, on March 30, 2006, the director of the East Tax Office issued a correction of the plaintiff corporate income tax for each of the fiscal years in question as shown in the correction of correction. Okay. On May 26, 2006, the plaintiff filed an objection to each of the reassessment orders. So, kasi nag-amend siya, binawasan niya. Ang tax authority naman, nagdagdag, no? So, nag-file siya ngayon ng objection or protest, no? On the reassessment or sa additional assessment sa kanya ng tax. So, on August 2, 2006, the plaintiff filed a petition for mutual consultation between the competent authorities of Japan and Malaysia. Mutual consultation, ito yung parang mutual agreement procedure. Ito yung dispute resolution, no? So, nag-file na siya ngayon between the authorities of Japan and Malaysia. Yan yung administrative remedy, no? Pursuant to the provision of the agreement between the government of Japan and the government of Malaysia for the avoidance of double taxation and the prevention of tax evasion. Ito yung sa BEPS, no? Yung base erosion and profit shifting. And then ito yung embodied also in our tax treaties. So prevention of tax evasion in respect of taxes on income with respect to the transaction with company C, which is one of the transactions with a related party outside Japan that is the subject of the reassessment. No? So itong sa Malaysia. So on January 6, 2010, an agreement for mutual consultation was reached between the competent authorities of the two countries only with respect to the corporate income tax for the fiscal year ending. Okay, so nag-confine lang sila doon sa corporate income tax. Okay, so fiscal years ending March 31, 2003 and 2004. And the agreement of mutual consultation hereafter referred to as the agreement of mutual consultation was concluded between the competent authorities. Under the agreement, the taxation of the transactions between the plaintiff and company C was to be imposed by the Japan Revenue Agency. So nagkasundo na sila. And the corresponding adjustment was to be made by Malaysian Revenue Agency. So ate sila. With an adjustment of 42 million yen to the plaintiff income for the year ended March 31, 2003, and 50 million yen to the plaintiff's income for the year ended March 31, 2004. No? So, ang laki ng assessment. Okay. So, in accordance with the above agreement, the director of the East Tax Office issued an order of correction dated January 28, 2010 to reduce the amount of income and the amount of tax payable for the year ended. Binabaan naman ng tax authority yung kanilang assessment. No? For the year ended March 31, 2003 and the year ended March 31, 2004 in respect of corporate income tax. Set out in the reduction in the amount of taxable income and the amount of the tax payable, mutual consultation, column of appendices. No? Mutual consultation, parang voluntary arbitration. No? So the opposition hearing office made a decision to dismiss the objection mentioned in C above on December 17, 2010. Okay. So on January 14, 2011, the plaintiff applied to the director of the National Tax Tribunal for examination of the reassessment. Parang nag-request siya ng investigation. No? And the director of the National Tax Tribunal made a decision November 8, 2012 to revoke a part of that assessment. Pinagbigyan naman siya na revoke yung ibang assessment. No? So, on May 14, 2013, the plaintiff filed this lawful, no, outstanding facts, disputes, and the parties' claims. So, yung plaintiff, sino yung plaintiff dito? Kasi Japan ito versus Uyemura. So, Japan ang plaintiff dito. So, the legality of the action for the revocation of the corrective action for the fiscal year ended March 31, 2003, and the corrective action for the fiscal year ended March 31, 2004. Yun ang kine-question nila, yung reassessment. No? The legality of the action for revocation of corrective action. Okay. So, dispute number 1, defendant's argument. Ano po yung sabi ng defendant? An action for the reversal of the portion of the reassessment which does not exceed the declared amount without going through the procedure of requesting for reassessment is not permissible as it lacks the benefit of action because it is a request for reversal beyond the scope of the taxpayer own admission. So in addition, in view of the fact that the mutual agreement on international double taxation is based on the consent of the petitioner, an action for cancellation of the part of the amount not exceeding the amount of adjustment agreed through mutual agreement would be an action for cancellation beyond the scope of the petitioner self-recognition. Therefore, it should be said that the appeal lacks the benefits of appeal. No? So, parang kulang-kulang doon yung appeal. Therefore, the action for the revocation of the part of the correction, which does not exceed the sum of the declared amount and the adjusted amount agreed by mutual consultation, should be inappropriate and lacks the benefits of actions. No? So, parang dinismiss nila na walang cause of action. So the agreement of the mutual consultation in this case is also premised on the consent of the plaintiff. The amount of income of the plaintiff for the fiscal years ended March 31, 2003 and March 31, 2004 is the sum of the amount of income declared and the amount of adjustment agreed upon by the mutual consultation in this case. As a result, the amount of income on which the claimant's claim is based, the amount of corporation tax to be paid, and the amount of additional tax or underreporting for the year ended March 2003 and 2004 are shown in annexes. So the plaintiff has not filed a claim for the cancellation of the portion of income, corporate income tax, and additional tax on underreporting, which should be based on the amount of income, corporate income tax, and additional tax or underreporting. So yun yung defendant's argument. Okay. May ano pa tayo? May viewers?
5 viewers.
Ano yung
56 minutes.
wala pa tayong 1 hour. Okay. So in agreeing the content of the mutual agreement, kasi yung mutual agreement ito ng parties, no? Because they are involved in the transaction. Kaya nga, mutual agreement. The plaintiff submitted to the National Tax Agency a letter entitled Confirmation, to which he affirmed that he would not sue for the portion of the adjusted amount based on the agreement, and it is considered that he agreed not to sue for the portion of the adjusted amount. No? So therefore, it is admitted that the parties agreed not to seek the modification of the amount by litigation. In addition, the plaintiff has submitted a written statement to the National Tax Agency entitled The Amount of the Tax, and it is acknowledged that the plaintiff has made a non-prosecution agreement not to seek to change the amount of the tax by litigation. No? So, parang nag-ano na lang sila ng compromise, no? So, furthermore, in the objection and the request for examination, the plaintiff excludes from the object of appeal the part of the reassessment which is based on the transactions with Company C for the fiscal year ended March 31, 2003 and 2004. No? So, Basic Circular on Corporate Taxation prior to the amendment by Act 2-5-2008, the same provides that in the case of simultaneous correction of corporate income tax for 2 or more consecutive fiscal years, the estimated amount of the tax payable as business tax for the fiscal year immediately preceding the relevant fiscal year, hereinafter referred to as the amount equivalent to business tax, shall be included in the amount of deductible expense as a special measure to consider the tax-bearing capacity of taxpayers. So the plaintiff argued that it's part of the reassessment should be reversed. No? So sabi ng Uyemura, lahat ng reassessment should be reversed. No? It is impossible that the entire amount equivalent to the business tax resulting from the increase in the previous year's income as a result of the reassessment should be included in the current year's deductible expenses in the event that the previous year's reassessment is reversed. If the previous year's correction is reversed, the amount of business tax deductible for the current year will be reduced accordingly. Okay. So ito maganda kasi yung case no? Ito yung argument ng Uyemura, no? So the plaintiff argued that its part of the reassessment should be reversed. It is impossible that the entire amount equivalent to the business tax resulting from increase in the previous year's income as a result of the reassessment should be included in the current year's deductible expenses. No? The plaintiff ignores this point and identifies the amount of the claim by starting from the amount of income in each of the amendment, from which the entire amount equivalent to the business tax has been subtracted and subtracting the amount of the disputed foreign transfer income. Okay. Kanina yun yung the defendant's contention. Ngayon naman sa claimant, no? Sa claimant na contention. No, ano sabi dito ng claimant? Actually, mahaba-haba pa to, no? Pero hindi na muna natin tatapusin, hari, kasi sobrang haba pa nito eh. Ayoko. Ha?
69 pages.
Ayoko siyang tapusin kasi may tatapusin pa po kami na transfer pricing analysis at saka may mga waiting pa rin na reports at saka nililimit na lang po natin ng 1 hour po yung ating live streaming para din yung ating mga viewers hindi rin sila masyadong natatagalan, no? So I would like to say thank you ulit po sa ating mga viewers. Kasi bago ko i-discuss itong claimant's contention, gusto ko tuloy-tuloy, mahaba ito. So, ituloy na lang po natin sa, kailan natin ituloy? Sa Monday, no? Tuloy natin sa Monday itong yung licensing ng intangibles at saka yung payment ng royalties. Kasi, ang laki ng assessment dito ng Uyemura, lahat yun ang galing sa licensing niya ng kanyang intangibles. So, I would like to say thank you and let's call it a night.